Indiana injury claim? Here are the secrets to pain and suffering. Pain and suffering is a huge part of any Indiana injury settlement. That's a fact. So a settlement is comprised of specials, state generals, but basically that's all fancy way of saying your medical bills, your wage loss, diminished earning capacity in some cases, and pain and suffering. So pain and suffering is a huge part of an Indiana injury settlement. So let's talk about that. The reason why people are entitled to compensation if they've been injured by the actions of another person is because the law says we should not bear the burden of somebody else's negligence. So if we're just living our life, taking care of our family, going to work, so an injury settlement is basically like the at-fault party's compensation to us for the damages we've experienced. And those damages include medical bills, wage loss, diminished earning capacity, and pain and suffering. So let's talk about pain and suffering. Pain and suffering, a lot of attorneys will say, oh, it's just 3 times medical. So if you got $5,000 medical bills, we should do a settlement for $15,000 and negotiate. That is the loser way of dealing with pain and suffering. It's too formulaic. It doesn't take into account the human approach of this stuff. So pain and suffering is affected by so many different things. Somebody that has a bruised bone, well, that's not fun. That's going to have X. Well, we can all agree that a broken bone is probably going to be higher than a bruised bone. Now, someone that has cracked ribs, well, when you have a cracked rib, it only hurts when you sit, stand, or sleep. You're literally going to be pain just breathing. So while a cracked rib might not be a broken leg type injury, the pain and suffering component of that is going to be higher, I would argue, than someone that just experienced a fracture, a bruised bone, or even a non-displaced fracture. But there's all sorts of factors that go into pain and suffering. And so the type of injury is very important. Also, how long was the injury going on before it was resolved? And how severe during that length of time was the pain? And then even within that pain, were you able to do the things you wanted to do? So if the pain was up here, but you had to take medication and you ended up sleeping a lot and missing kids' birthday parties, missing bowling tournaments, missing going to the movies with your spouse or significant other, if it affected your life in a negative way, well, that increases pain and suffering. So simply because I took medicine wasn't that bad. Well, what did that medicine cost you? Did you not read your favorite novel for 6, 7 months, even a year? We have cases here where same injury on a teenager versus a person in their 60s, well, a teenager bounces back a little bit faster. Younger people heal faster, as I'm finding out as I get older. The age affects all of these things. And so pain and suffering isn't as easy as simply saying, well, it's 3 times medicals. No, that's the loser approach. And if an attorney tells you that, no, I don't refuse to accept that. Because simply taking a multiplier of a medical does not take into account the human approach of what is going on with the pain and suffering. The purpose of pain and suffering as part of an injury settlement is to try to make the person whole or as close to whole as they were before they were injured by another person's negligence. And that's super important to remember. I wish I could give just some general examples of pain and suffering awards, but it's challenging because we had a case where a lady was backed into while she was walking out of a big box store, and we argued that her pain and suffering was worth millions of dollars. And the jury agreed. We also have cases where people sign up and they heal faster than we thought. And we're happy about that. We don't want anyone to be in pain, but typically younger people kind of bounce back faster, and their pain and suffering award isn't as great absent some sort of debilitating injury. But we've also had young people that could no longer play sports, lost a scholarship because of injury. And obviously that pain and suffering is going to be much, much greater than someone that simply went to the hospital 2 times. But every case is a little bit different on the pain and suffering scale. A lot of attorneys, if a person is unable to be back to 100%, a lot of attorneys and insurance companies will use mortality tables. Mortality tables are something that are used when a person continues to have pain long after their original injury and a doctor testifies, hey, the pain's not going to go away. It's something they have to live with. So the longer somebody has to live, well, the greater pain and suffering award for that debilitating injury. Now, sometimes insurance companies will say, well, an older person being injured isn't really entitled to as much pain and suffering than a younger person because, well, Mark, they're already older, they're already experiencing aches and pains, they're already retired, so they kind of know what's. No, that's garbage. That's absolute nonsense. We have other videos on that, this myth that older individuals aren't entitled to as much pain and suffering. No. If you are an older individual, you've made it through life's tribulations, and we all have them. You deserve as much as anybody else to be in a pain-free or as near a pain-free existence as possible without somebody else coming and causing chaos in your life. So never accept the fact, well, you're elderly, I'm not going to be able to give you as much money because, well, you're old. No, it's horrible, and that's nonsense. Never believe that for a second. Now, one thing that does affect pain and suffering is if a person who was injured contributed to their own injury, and that's called comparative fault, and that does happen. Think about it. It sounds kind of unfair at first, but it makes sense. If you are walking on a hill and reading your cell phone and you don't see a rock in front of you and you slip, well, that rock kind of caused the injury and so did you because you've been paying a better attention, maybe you wouldn't fall. So that's the basis of that, but we have situations too where people are at the movie theaters and they're wrangling their children together, but there's trash and debris on the floor and the person slips and falls. Maybe they should have been paying better attention to where they're walking, but don't we also, as guests of a movie theater, have expectation that the floors are going to be clear and clean and allow for us to travel on while they take our money for the candy and popcorn and the matinee? Yes, we absolutely do. But a jury can say, well, you should have paid better attention. Maybe you're 10% at fault, but the movie theater chain is 90. They can reduce the pain and suffering. They can reduce the entire settlement by 10%. And insurance companies will try talking about that as well. Well, don't you agree you're a little bit at fault? Don't you agree that you could have done a little bit more to prevent this? You have to be very careful what you say to an insurance company, especially if you're handling the case on your own. So the amount of fault that you were in will reduce your settlement. So be careful talking to the insurance company. And they're smart. They take trainings on how to make people say things that make them appear a little bit bad. Oh my gosh, I'm so happy you weren't hurt worse. Oh, that's fantastic. Well, everyone speeds, right? Yeah, everyone speeds. Oh, you just made an admission to speeding. Don't do that. Be careful what you say to insurance companies. Even better, let your attorney talk to an insurance company. Now, how do insurance companies decide what to award in pain and suffering? Well, there's lots of different things. Insurance companies will look at the trends at jury verdicts across the country, but more specifically for Indiana cases in Indiana. And the trend has been going up a little bit, probably because attorneys are bringing better cases to jury trials, but the trend is going up. And so adjusters will look at the fact, hey, what are juries giving for pain and suffering? And they'll reduce that by the fact not having to go to a jury trial, but they'll also factor in, can the person they're talking to actually convince a jury to give them that amount? If you're not an attorney, well, chances are you probably can't convince a jury to give them that amount because, well, you're not an attorney. You don't do jury trials. Even attorneys who try to negotiate cases, insurance companies keep exact detailed databases on which law firms actually go to trial. And attorneys that say, well, I'm an injury attorney, but they don't actually go to trial, well, they're not going to get as big of settlements as attorneys that actually go out there and do trials. That's a fact. So there's lots of things the insurance company is looking for. Jury verdicts, whether the person is capable of obtaining that jury verdict, and whether the attorney has even done any juries in the last 5, 10, 20, 25 years. All those affect the settlement amount, plus whether the insurance company genuinely believes the person who's injured caused some or all of their injuries. Those are some of the secrets of pain and suffering for Indiana injury claims. Now, here at the Mark Lopez Law Firm, we understand that people who have been injured in accidents, car crashes, slip and falls, dog bites, we understand they often experience a great deal of frustration because dealing with insurance companies and injuries is never fun because you still got to deal with your normal life. Allow the Mark Lopez Law Firm to turn that frustration into compensation. Give us a call today, 317-632-3642.